Yeah, this remains one of my best. Huh? When I say my best, one of my favorites.
Crying.
But you expect to only hear these sort of tunes when it's not yet election time and independence time, and so no. For Randy Isaac like that, we're taking it back to the top, ain't it? Nice.
I'm strong, I'm strong. I am a Grenadian. Yes, man. Grenada, the land where I was born. I know you were suffering. Men have raped you and abused you and left you there crying. I devote my heart, my body and my soul. I stretch forth my helping hand to help you out. I haven't got diamond, silver, nor even gold, but blessings I give to east, west, north, and south. Oh, Grenada, Grenada, here I come, sweet, sweet Grenada. I will never, ever, ever let you down. Oh no, I'll always be your support. Right here by your side, with my arms around you to wipe your weeping eyes. Oh yeah. It's quite a long time now since you have fallen back to the last rung of the ladder, and your neighbors stand up there and uttering no talk, but to help they just don't bother. Some of your friends have turned their backs on you. They don't want to see a friend with your name on it. Don't bother with them, one day you will rise up too. Cause in times to come, is the bread they might have to eat. Listen, let me go. Oh, Grenada, Grenada, here I come. Sweet, sweet Grenada. I will never, ever, ever let you down. Oh no, I'll always be your support. Right here by your side, with my arms around you to wipe your weeping eyes. Let we go. Listen, it's time that you take a stand to defend your position from all those smart rip-off scams who just come to take a bite and make their own decision and boast to the world that they are the reigning champs. While your friends, them happy, had times they were going through, they still wouldn't help you out if you beg them please. But woe unto them, little do they know that a good name is better than great riches. Oh, Grenada, Grenada, here I come. Sweet, sweet Grenada. I will never, ever, ever let you down. Oh no, I'll always be your support.
Yes, and we're back, yeah? And as I promised you, we would have some individuals in studio with us this morning to speak about constitutional reform and the Caribbean Court of Justice specifically. And I have in studio with me no stranger. Now, ladies first. Let me go to ladies first. Right. Well, still no stranger to hard talk, you know. Mrs. Steelers listen hard talk when she have the opportunity. So I'll say a special good morning to you, Mrs. Michelle Steele. And she is representing the committee as well in relation to the Caribbean Court of Justice. And she's going to be giving us some information in relation to that, along with a gentleman who is absolutely no stranger to Hard Talk Studios, Dr. Francis Alexis. And good morning to you, sir. Let me just put the mic a little closer to you.
Good morning to you, Sheldon, you and your listeners, viewers. It's always a delight being with you, sharing opinions with you.
Yes, indeed.
And Sheldon, good morning to you and to your listeners. Thank you for having us here this morning. And we certainly hope that we can provide as much enlightenment as possible.
Yes, and I love that word, enlightenment, because we are going to enlighten the public about what is taking place right now in relation to this particular issue. What is the status quo? What is happening right now? What we have the potential of happening if we acknowledge and we decide that we're going to the Caribbean Court of Justice, and also the process that we're going to use to the constitutional reform and the particular issue of the CCJ. Dr. Alexis, I don't know if you want to lead off on this particular issue. Give us a little rundown for those who may not be too familiar with the particular issue of the present situation as occurs with Grenada and the Privy Council and the CCJ.
The Independence Constitution of Grenada, made in 1973 in London, but brought into force 7 February 1974, Independence Day, provides for appeals from our Court of Appeal to Her Majesty in Council, as the Constitution calls the Privy Council. Materially, some appeals lie as of right, some others with leave, meaning permission of the Court of Appeal, and many others with leave, permission of the Privy Council. The Constitution of Grenada specifically enables the abolishing of appeals to the Privy Council without a referendum. And indeed, during the revolution, early in the revolution in 1979, appeals to the Privy Council were abolished by the revolutionary government, and the Privy Council did accept that the abolishing of appeals to the Privy Council had been lawfully done. Moving out of the Privy Council is one thing. Acceding to the appellate jurisdiction of the Caribbean Court of Justice is, however, a different matter. For example, just as in Grenada, so too in Jamaica, that country can move out of the Privy Council without having to observe deep levels of entrenchment. However, the Privy Council ruled, in a case from Jamaica, that Jamaica moving out of the Privy Council is one thing, and that could be done simply with a 2/3 majority in Parliament, but their lordships added, replacing the Privy Council by another final appellate court, in particular the CCJ. It's a horse of a different color. Now, their lordships did not say what was required by Jamaica to make that clean break, although that was specifically what Jamaica attempted to do in 3 Acts of Parliament. So that Grenada is similar to Jamaica in this respect, in that we can move out of the Privy Council without a referendum, But on the authority of that Jamaican case, if we're now going into the appellate jurisdiction of the CCJ, that's a different matter. And that is why we have to go to the people of the country and plead the case with the people for the people to decide yea or nay going into the appellate jurisdiction of the CCJ.
Okay. So our present situation is that our final cases. So today, the businessman out there that's listening right now and has a legal matter, his final court of appeal right now is the Privy Council. Once he's gone through the various stages.
Yes, not only the businessman. We had this police officer coming down from St. David's a few years ago. His car ran off the road.
Mm-hmm.
He wanted to get a higher level of compensation from NIS, but he could only do that if he could put himself in a certain category. The High Court said he couldn't put himself in that category. Court of Appeal said he couldn't. He started making arrangements to go to the Privy Council. This is an ordinary Joe Bloke Grenadian.
Mm-hmm.
He was required by lawyers in London to put up £30,000. He reached £20,000. They started the paperwork. Then the lawyers in London told him, sorry, his down payment, which is about $20,000 or 15, I'll get the figures for you.
Pounds, not
talking
DC dollars.
We're talking
That's
of
correct.
pounds. That's £36,600, which would equate to about 140,000 Grenadian dollars. So he paid down £20,000, which is equivalent to about, say, 85,000 Grenadian dollars or so. Then the lawyers in London said to him, we have to tell you, you have to pay now more than £36,600, and we can't tell you what will be the maximum.
So
What
it
is
can
going to-
increase.
It can increase almost infinitely. So he says to the lawyers in London, I'm sorry, there's no way I can raise that money. Can I have my money back? My £20,000. They say to him, sorry, you can only get back £7,000. Now this
So
is
he
not
lost 13,000
just
pounds.
like that, £13,000, and he hasn't gotten anywhere near to the door of the Privy Council yet. So that this
But
issue
before
of,
you go further, the other thing is just how much would he have been getting back from NIS in the first instance to have to spend that amount of money?
but the principle involved was warranting him trying to get to the final court.
Mm-hmm.
Because it's not just for him. As a matter of fact, NIS too wanted the matter cleared up. So we're back now to square one. The NIS isn't sure what to do, and the people are not sure what to do. I want to contrast that up with a situation that obtained in Guyana last year. This is a poor person in Guyana wanting to accede to the appellate jurisdiction of the CCJ.
Mm-hmm.
His lawyer is in Guyana. And when I say in Guyana, I mean at his home in Guyana. And this is what the CCJ said. That this lawyer, and this statement is made, as I say, just literally a few months ago. And this is what the CCJ is observing here. That this lawyer, sitting in his home in Guyana, not even going into Georgetown or a courthouse, had the distinction of being the first counsel to appear from his Guyanese home via this court's advanced video conferencing facilities and argue the appeal. You're not talking about £7,000, not talking about $7,000. The man is staying at his home and argue his appeal. That is the facility the CCJ is offering the Caribbean people.
let me ask you, Mrs. Steele. Um, the CCJ, you're a practicing lawyer right now.
Yes, yes, that's
What
correct.
has been your interaction with your other colleagues and so as regards the CCJ, and also what has been your interaction with your colleagues re the Privy Council? What are some of the things that you have come up against in the years that you've been practicing?
Well, Sheldon, it's very interesting that you said, or when you posed the first question about the businessman listening today, what would they or how would they be able to access the Privy Council? Because there raises that argument that we have this Privy Council, which is distant, is in England, it's set up by the Privy Council Act, a very old act in 1833, and it has permitted us to all or many Commonwealth countries to access this Privy Council as our final court of appeal. I have similarly a client, and he was a businessman, and for him to access the Privy Council, he was also told that he would have to pay £20,000 up front. This is before any of his lawyers from the Caribbean step on a plane, go to a hotel. You have to have meals. You're basically representing your client's interests. So it's wider than simply sending a fee to solicitors in the UK. It's also covering the expenses of your solicitors, apart from their professional fee. Then you also have to look at the fact that in terms of speed, I wanted to add on to what Dr. Alexis is saying with the CCJ, where the CCJ has really used technology or is using technology to be able to render or to administer justice to persons or litigants applying. Because you have a situation just yesterday where the Barbados elections, as you know, they are on the 24th of May, they're upcoming. And there was a citizen who had a complaint. He is a Commonwealth citizen living in Barbados, and his complaint was that he was not permitted to register to vote.
That's the St. Lucian
Contrary, correct. Contrary to the laws of Barbados. The CCJ agreed to hear this matter yesterday on a Sunday by teleconference. So they would have sat in the court, which is headquartered in Port of Spain, Trinidad, and they would have heard lawyers from Barbados via the internet and using, the available whatever applications to permit, this happening. And this is fantastic, because when you consider justice delayed is justice denied. Sometimes we have a matter where we need an issue determined. Otherwise, and if it's not done in a very speedy fashion, then it's really moot. And, it's like, okay, well, maybe in the next 6 years or in the next 5 years. In this case, we have the Barbados election on the 24th of May. So that's about 10 days away. And they were able to hear the matter and give a decision. And basically, they did indicate that he was correct. He was entitled to be registered to vote. And they would have issued certain directives to the supervisor of elections there. So I think it's very important to understand that the access to justice, the accessibility to justice by a wide cross-section, by everyone, is so important. Because at the end of the day, this is really, at the end, where you get your relief. So you have this obstruction, I would say, or hurdle to cross, this financial hurdle to cross, from the time you contemplate the Privy Council. There are even parts of the rules of the CCJ which permit litigants, and Dr. Alexis is the expert here, to come to the court and not even pay for free, because there's that importance, I think, recognized by the court for the development of our West Indian jurisprudence.
Now, there's a similar thing with the Privy Council, but that only obtains to a person on the murder cases and so on, that these individuals could receive their lawyers that would do their case, and so they don't have to appear and all of that, and their cases can be heard in the Privy Council. But the average man or woman in Grenada, that doesn't obtain for them.
No, it's only in these life and death situations in London that Caribbean persons might get this expedited and facilitated access to the Privy Council, because you have people in London who make available resources for those purposes. But the sort of case that Michelle was just referring to, access to vote, for example, you're not going to get to the Privy Council. It has never happened that you've gotten to the Privy Council as speedily as that, which raises the question, why then are we talking about the Privy Council at all today and moving out of it into the CCJ, when 2 years ago or so, the people of Grenada, Carriacou, Petite Martinique voted on the bill. And I want to go back to that, Sheldon, so we can appreciate what is it we're doing. There were 7 bills put before the people in referendum 2016. Of all of those bills, bill which attracted by far the most attention of the people is the CCJ bill. I want to emphasize, Sheldon, I am not saying that the CCJ bill got more yes votes than any other bill. That's not what I'm saying. As a matter of fact, the name of state bill got the most yes votes. What I'm saying is that more people took time off to address the issue of CCJ than any other bill. Here are the statistics. 22,274 people voted on in relation to, as regards, the CCJ bill. I'm not saying majority voted for, I'm just saying how many people voted on the bill. The next bill to get the big attention of the people was the name of state bill. 22,179 people voted in relation to that bill. Now, the fact that so many people voted in relation to the CCJ bill is of vital importance, because that was not the bill which attracted more excitement in the country. As we know, you even had churches on the streets regarding what you might call the human rights bill. So you had a lot of focus on the human rights bill because of a certain clause in the bill. Yet, more people voted on the CCJ bill than on any other bill. What does that tell us? Any reasonable, impartial observer must conclude from those statistics that the people of the country were saying on referendum day 2016 that the CCJ bill is the one they want to hear more about. You remember Paul preaching to Festus? And Festus is saying, come back at a more convenient time. Well, the people of Grenada were saying, you're trying to convince us about this bill, come back at a more convenient time. 2016 was not a convenient time for them. Why? Because you had all of these bills, 7 of them, with a lot of subheadings. So they were saying, come back at a more convenient time, come back with that bill alone, so we can focus on it without being distracted by other things. And furthermore, go and clean up the bill. These are the things you have in the bill about Attorney General, whether you want to call a judge, a High Court judge, or a puny judge, and in particular, this matter of the Code of Ethics. We don't want to deal with those issues now. Come back at a more convenient time with the CCJ bill, cleansed of these other things. And that is what is happening now. Here we go again with the CCJ bill, cleansed of Code of Ethics, cleansed of, Attorney General, cleansed of, and this, I know, this caused a lot of debate, a clause in the bill which was saying that we're going to raise retirement age of the judges, which I think should happen. But the point is, Sheldon, that a referendum is not about the political or moral views of, say, the government of the day primarily, or the authors of the bill, or that sort of thing. So it's not what Sir Lawrence Joseph believes in. It's not what Michelle Steele believes in, or Francis Alex. It's a matter of what the people want to hear. And we are very clear in the messages we got in 2016. The people want a CCJ bill by itself. Now, there's one other clause in this bill this time, and it wants to change the name of the court from the Supreme Court of Grenada and the West Indies Associated States to the Eastern Caribbean Supreme Court. That is how the court is called everywhere else in the world. Grenada is the only rock on the planet which refers to the court as the Supreme Court of Grenada and the West Indies Associated. And there are no West Indies Associated States. So that is how we are having this conversation again this time around.
Okay, let me ask this question though. I know the last time around there was also a bill separate to the other bills that dealt with the reordering. Will this change, once successful, cause a reordering or renumbering of any aspect of the Constitution, which would mean that you also have to include that bill again as well? So it would be the bill that is basically just administrative, that says you're going to change the wording in that section of the Constitution, or you're going to change, because it may affect the number of sections.
There wouldn't be any reordering or renumbering.
There wouldn't be
All
any
that would
reordering or
happen is that
renumbering.
you go to the Constitution, and wherever you see the expression Her Majesty Council, you strike those words, and you put Caribbean Court of Justice. Wherever you see the expression Supreme Court of Grenada and the West Indies Associated States, you strike out that expression and you put Eastern Caribbean Supreme Court.
So all of that would be contained in this one bill. So there
Yes.
wouldn't have to be a separate bill that says, okay, changing the numbering here, we're changing the wording here,
No.
changing he to he and she, or anything like that.
No,
Okay. I was just making sure. Yes, indeed, listeners. And again, we do have in studio with us Dr. Francis Alexis and also Mrs. Michelle Steele, and we are speaking about constitutional reform. I think Devon should be somewhere around the building. I know he's outside, he's just waiting to come inside. So we'll get him in a short while. But we're speaking Caribbean Court of Justice. As you know, the government of Grenada and Her Excellency, the Governor General, Her Excellency Dame Cecile Lagrenade, did mention in her throne speech a couple of weeks ago that the issue of the Caribbean Court of Justice would again be approached via the constitutional reform process. And you would have also heard immediately after the election campaign, Dr. the Right Honorable Keith Mitchell speaking the same language as well. Let me ask this other question. How many countries still use the Privy Council? Why is Grenada trying to stick to something that it seems other countries are moving away from? How many countries use the Privy Council right now in general?
The figures generally are that in the Caribbean, Jamaica, Trinidad and Tobago, the Eastern Caribbean, apart from Dominica, and about, I have the figures exactly, about 4 other countries in the Commonwealth still use the Privy Council. No major country in the Commonwealth uses the Privy Council. Not even
Canada?
Not even the United Kingdom. The United Kingdom does not use the Privy Council as its final appellate court.
So they've created the Privy Council, we have accepted the Privy Council along the same lines when we accepted independence, when we got our independence, and so the United Kingdom is no longer using the Privy Council.
Has never.
They have never used
They have
it.
never used the Privy
Yes,
Council
House of
as a
Lords.
final appellate court. They've always used, historically, the appellate committee of the House of Lords. And since 2009 or so, they now have the United Kingdom Supreme Court. Now, it's the same judges. So when they're sitting in the United Kingdom Supreme Court, they're here. When they're sitting as a Privy Council, they're still here too. So, but certainly no
They
country
just change the
like,
wig.
change the wig. Canada, Australia, New Zealand, African countries, Asian countries, they've long ago, many moons ago, ceased. I like to discussing it in relation to Canada because you see, in 1949 or so, the Canadians started this matter of discussing Canada pulling out of the Privy Council. And a gentleman who went on to become the Chief Justice of the Supreme Court of Canada wrote an article on the matter. I think he published it in the Canadian Bar Review. And the arguments he used then are arguments we can use now. He was saying, for example, when you are coming to discuss your constitutional law problems, you want to do that in your locality because judges in your locality appreciate what is needed by the Constitution. Actually, the Privy Council judges themselves keep making that point from time to time in relation to the Caribbean. Routinely, the Privy Council judges will say in constitutional law cases, public law cases, that judges in the Caribbean are far better placed to understand what public law requires in the Constitution than can Privy Council judges sitting as their lordships will say so far away. They do add, however, that does not mean that they can never reverse Caribbean judges, and they do that from time to time. But the point they are making is that they would prefer that Caribbean judges decide Caribbean public law cases because of those reasons there, among others. So this debate has gone around the Commonwealth for many years. And I remember when Ceylon, now Sri Lanka, became independent, the Chief Justice of Ceylon was saying in a case that independence cannot be separated from final judicial decision making. Oh, Sheldon, you should have heard the Privy Council go to tongue on that Chief Justice. And I know that I've never seen the Privy Council speak that way. The way they spoke about that Chief Justice of Sri Lanka. I've never seen them speak that way about judges from Canada, Australia, New Zealand. When they're speaking about judges from those countries, they speak with circumspection. But the way they dressed down the Chief Justice from Ceylon, Sri Lanka, was quite an eye-opener. Let's put it in context now. The Vice Chancellor of the University of the West Indies today, Professor Sir Hilary Beckles, is heading a Commonwealth Caribbean-wide reparations commission. They are saying that Britain and other European countries must come to the table to talk about reparation to the Caribbean for what was done during slavery, and for that matter when East Indians came to the Caribbean, and for that matter what was done to the original inhabitants of these countries, the Caribs and the Arawaks. As you know, for example, here in Grenada, the French chased the Caribs up to the north of the country, and the Caribs had to jump over into the sea. They lost their lives. The Caribs sleep over there now. So that commission is raising this issue in the same way that Jews have been given reparatory justice, Caribbean countries are entitled to it. Now, what if that case goes to the Privy Council? Suppose there's a case on it, and it goes to the Privy Council. At the very least, that's going to be very awkward for the Privy Council judges. Why? Royalty was involved in slavery and the slave trade. Members of the House of Lords, members of the House of Commons were involved in slavery and the slave trade. Members of the Church of England were involved in slavery and the slave trade. So you're going to ask the Privy Council today to sit in judgment as to whether kings and queens of the United Kingdom have committed these atrocities and must pay? That's going to be very awkward. So when we're talking about finalizing our appellate justice system, we're not talking about whether you're in NNP or in NDC. That's not the issue here now.
Irrelevant.
The issue is who is going to decide finally the meaning of our Constitution, what is meant by civil justice, what has history done to us as a people, and how are we going to address that? These are the items on the agenda.
No, I like what you have said, especially because I think some persons already are trying to make this into a political issue and a sort of political football. And while they're saying that, the problem continues that, let's say the market vendor that right now she has an issue. Let's say she has an issue, an incident takes place and she has an issue. While her final court of appeal, throughout the entire matter, while she may have a sound case that can go forward, her final court of appeal is the Privy Council. But before she can get to the Privy Council, she's got to find that £20,000, not EC, we're speaking here pounds, £20,000 to apply to the Privy Council for that case. She's also got to find probably around another 20,000 by the time you consider the tickets for her local legal counsel, and then lodging, etc., in the UK for a case that could be seen after by someone down here in the Caribbean. So it's basically denying justice at the highest level to Grenadians who cannot afford. It's putting justice at that level that you have to be a multi-millionaire basically to be able to argue the simplest of cases at the Privy Council, whereas you have the Caribbean Court of Justice that is available for everyone. The policeman who had that issue coming down from St. David along with the NIS, that issue could have been thrashed out in court at the CCJ level, that a policeman or a nurse or a teacher in Grenada that has that problem can go to the CCJ, whereas they cannot go to the Privy Council. I'm saying that in the context of a lot of individuals seem to be of the mindset that the people in the Privy Council don't know us, and therefore they are better to judge us. But that the Caribbean people know us, and somebody going to pull a string, and they're going to tell this one what to do, and that sort of thing. Mrs. Steele, first, what do you say to that?
Well, there is that level, let's call it distrust. Let's call it a lack of confidence in our own Caribbean people. But there are, I think, important things to say in relation to the structure of the court and the way it has been set up. The judges, first of all, on the CCJ are made up of a mixture of West Indian judges as well as persons from international experience. Mm-hmm. So there is that wide, I would say, cross-section which can give you a good perspective on matters, etc. Mm-hmm. For you to pull a string in relation to the CCJ, the judges are also ruled or regulated, or their conduct is regulated by the rules of the CCJ, which are very, very strict, and they are required not to or to function independently. It's really a matter of understanding or recognizing whether we are mature as a people to take this leap of faith, to believe in our local institutions, and to move forward together into the future where we really develop this court and ascribe to our own court. It is very easy to say that, oh, well, people up there don't know us, so at the end of the day, we don't have any worry about them, being affected by one person over the other. But in saying that people up there don't know us, they also don't know our culture. They don't know our traditions. They don't understand how our societies work. And part of that, or that understanding, is part of the platform to really developing our jurisprudence. So as you would have indicated, you would have people who have issues that really need to be tested and thrashed out in the court. Dr. Alexis would have spoken about a matter in NIS. And then NIS was also interested in this matter being resolved and ultimately decided. If a court also is not available to decide these issues, then we cannot have legislative reform. Remember, the state functions, there are three arms of the state. And part of that is the judiciary and the legislature and the executive. And you will find sometimes that laws are developed, improved, evolve based on the judicial interpretation of those laws. So you're basically saying, look, you know what? I feel that we would get a really good decision if we move to the higher level or the highest level of the court. Mm-hmm. Currently, all we could say is, you know what? We have to stop here because the money done and we don't have the facility, right? Our case is not of a category, which, as Dr. Alexis would have explained, is not life and death. But at the end of the day, our case is of importance to the future, to how we develop, to our future generations. But how do we really decide this if we can't afford to decide it, or if we feel that, we're not mature enough to decide it? At some point, we have to determine that we are holding each other's hands and walking into the future together. We put in as stringent controls to regulate our judges. We discipline them and ensure that no one is allowed, or they're held to be accountable, and there's ultimate transparency. And this is how we really develop as a people. Right now, Belize, Barbados, and Dominica are the countries within CARICOM that have acceded to the final appellate jurisdiction of the court. I think it's important for us to recognize that all CARICOM countries are a part or can access the CCJ, including Grenada, under their original jurisdiction. And that would involve, for example, all the issues relating to the Treaty of Chaguaramas. That treaty has to do with things like trade issues in CARICOM, the movement of persons in CARICOM. I'm sure you remember that famous case, Shanique Myrie, where she was a young Jamaican girl who went into Barbados, and the Barbadian immigration authorities, they strip searched her and they questioned her and they didn't allow her in and whatever else. And she went to the CCJ and she got her justice, and she was ordered, or the Barbados government was ordered to pay her compensation, because we have a CSME, a Caribbean Common Market, and our CARICOM nationals are or should be permitted to move freely. So that's just one of our rights as CARICOM nationals. So we can access the court in relation to those issues. We are simply saying, okay, let's take the next step. The court has been established, it's been functioning, it's been showing its efficiency. We have not heard any cries of foul. Oh my goodness, there's the old boys network. So why can't Grenada at this point have this conversation and make this decision?
I want to weigh in on that. I agree, of course, with everything Michelle has said there. But I'll tell you, Sheldon, you see that suggestion that we are not either mature or fair enough to decide our final cases, that to me is the deepest cut. That makes me sadder than any other thing said. Here we are, Caribbean peoples. We've come out of history, a history of slave trade, slavery, colonialism, Windrush, and still we are saying to some extent, when we want justice, we must go to the same London seat of Windrush, the seat of colonialism, seat of imperialism. That really brings tears to my eyes, I tell you. Secondly, we have been running independence in the Caribbean, case of Jamaica, Trinidad and Tobago since 1962, Grenada 1974. And you cannot point the decisions of our judges which tell you that Caribbean judges don't have a sense of justice in their bosom. When Jamaica moved into independence, Jamaican Court of Appeal, including Alan Lewis, who moved on to become our first Chief Justice in the Eastern Caribbean, interpreted a clause in the Jamaican Bill of Rights to prevent the state from subjecting a person to, say, manslaughter if he had been tried on murder and not found guilty. And it was the Privy Council which said, in effect, Jamaican judges, you're too liberal for me. You have to interpret that clause in the Bill of Rights the same way they would have been interpreting it in London at the common law over the years. Keep it at the common law. And they've been doing that time and time again. Most times, I'm not saying every time, most times a provision in a Caribbean constitution is interpreted in a generous and liberal way. It is when it is done so in the Caribbean. Sometimes even a dissenting judge. If you take the Antiguan case, Observer Publications, where the Privy Council said the Observer Publications people had a right to get a license to operate the FM radio station. I agree. No judge in the Caribbean had taken that viewpoint. But time and again, I just give you one from Jamaica. And this is early independence, so that I think Caribbean judges sometimes they must be a little confused. They step out liberally and generously, go back to Antigua. Parliament passed an act requiring you to have a license to operate a newspaper. The trial judge and the Court of Appeal said that license fee was so high, it amounted to an interference with freedom of expression. When it got to the Privy Council said, no, that's not too high. Parliament was entitled to do that. So sometimes you get the impression that the Privy Council has a knack of pulling back Caribbean judges when they want to be generous. And if the Privy Council steps out, then you hear people say, you see, the Privy Council is bright. No. Take Grenada. Look at many of the judgments coming out of Grenada over the years. Only last year or so, Gemma Bain Thomas is suing the state, former cabinet secretary. The state is saying, no, we had a right to kick you out. Which is the court that said the state wronged her? It wasn't the Privy Council, our own Court of Appeal. Even the trial judge took the view that the state was wrong. I represented a guy many years ago. The state had turned him out of the public service. We went to court, we said what the state did was wrong. The trial judge didn't agree with me, but the Court of Appeal agreed with me. And that gentleman is getting his just desserts up to now. He's being paid his pension. And I can take you through case after case where Caribbean courts have ruled against the state in favor of the individual. Thank God, I have to say, Caribbean governments don't come out and, generally speaking, when that happens, they don't come out and make a fuss. So that the point I'm making is that the track record of Caribbean judges shows that, by and large, Caribbean judges get it right, and they are no less liberal and generous than. It was not until the CCJ came into action that you had a court ruling. If a person was in a governmental position, no longer there, and we think that that person abused the state resources, you can't bring a civil action. The Attorney General couldn't bring a civil action against it. The state had to bring a criminal action where the standard of proof is very high, beyond reasonable doubt. If you could bring a civil suit, we only have to prove it, balance of probability, you stand a better chance. No court in the Commonwealth accepted that argument. It was only the CCJ 2 years ago or so which accepted the argument in a case from Belize.
Which is more fair.
Of course it's fair.
Because you could actually reclaim from that person
Precisely.
what it is they would have pilfered from the state.
Precisely.
In this civil action, you could impose a fine and imprisonment, etc. But at the civil level, you could also reclaim.
Reclaim. And the Privy Council sat there for centuries and never allowed the state to bring a civil action to recover stolen properties, so to speak.
Is it what one of the listeners, my good friend Deepo, is calling intellectual racism? You wouldn't go that far. You may have to appear before the Privy Council. I could go that far.
Thirdly, as I said, this point, and only Saturday, a person was telling me the same thing. And I was walking him through these arguments. And then he said, all right, well, I'm seeing it better now. Look at what the Privy Council has had to say about the CCJ. Same case from Jamaica, 2005. This is what the Lordship said. They were looking at the clauses in the CCJ agreement, and this was the conclusion of the matter. The board, meaning the Privy Council, has no difficulty in accepting and does not doubt that the CCJ agreement represents a serious and conscientious endeavor to create a new regional court of high quality and complete independence, enjoying all the advantages which a regional court could hope to enjoy. So here is the Privy Council testifying to the world. This Caribbean Court of Justice, which has been established, it has guarantees of complete independence. But yet you may find some people, that Caribbean Court of Justice, the politicians and the businessmen can get to it. Now I say again, throughout our history as independence peoples in the Caribbean, our judgments from our judges do not warrant that fear.
I'm going to ask a question and folks, we can start taking your calls. 440-7377, 440-7377, and 347-329-3101. That's 347-329-3101. We'll open the phone lines and we'll start taking your calls. And good morning to all of you on the live. The last attempt at constitutional reform, we had a lot of the churches and other individuals coming out and speaking about the Buggery Act and that it may have been legalizing that. Now, let's look at it in this perspective. If a case is brought presently against the government of Grenada by certain segments of society in relation to that particular point in criminal law here in Grenada, and it goes to the Privy Council, how do you perceive, considering some of the judgments that have been coming out of the Privy Council as it is right now, considering the state of affairs in the UK as relates to this particular issue at this point in time? What do you think? I know you may not want to, to say outright, but what do you think most likely would happen if something like that comes about right now and it goes, because it definitely will go to the Privy Council. It will be going to the Privy Council. What do you think the state of play is right now? Dr. Alexis,
No, I have absolutely no doubt. I have absolutely no doubt. You look at the decision of the Privy Council in a case from, I can't remember where now. I spoke about it a lot during the 2016 referendum campaign, that the Lordships made it quite clear that the clause equivalent in that country to the clause here in Grenada, which guarantees freedom from discrimination based on sex, entitles the individual to his or her sexual orientation as a general principle.
Mm-hmm.
And it is as clear as these things can be. As a matter of fact, over in Belize, the court over there has similarly interpreted that clause in Belize, equivalent to our clause in Grenada, which gives protection against discrimination based on sex. The court over there said that this protection extends to and confers a right of sexual orientation within limits. For example, limits having to do with age, limits having to do with consent. These were the two limits set across there. So I wasn't hesitating at all. It's just that I've been speaking for a while and I was allowing Michelle to catch the ball. But I have no doubt about that.
Yes, indeed. Your views on that particular issue, because we know it definitely once again will become one of the contentious issues as we discuss the issue of the CCJ as opposed to the Privy Council, especially by those who are attempting to destroy the entire process for whatever political means or whatever, that they are going to take that approach again. But I think more and more, from some of what I've been reading, we've been seeing more and more liberal, more and more sort of liberal judgments coming out of the Privy Council in relation to issues that do not necessarily reflect the states that they are sending those judgments back to. And it is definitely something I think Grenadians need to take a serious look at while looking at the issue of the CCJ, as to how, do these people really understand us, and do they understand what we see as normal, what we see as abnormal, what are our beliefs, do they understand the Caribbean when they're making judgments for us?
Well, I think that as we look at, say, law in society, it's very important to have the understanding of the society, of the community, of the beliefs, and what a lot of communities still hold dear and sacrosanct. And so I think that the CCJ, of course, being a regional court, would certainly have those sensitivities or sensibilities. That issue, that particular issue, which I sort of deferred to my senior Queen's Counsel, as they say, is a very, as you know, hotly debated.
Throughout the Caribbean.
Hotly debated. And, it really is a matter of really understanding how it's going to evolve, especially with the liberal views that are being taken, not only by what we have seen coming out of the Privy Council, but also in terms of international treaties, etc. There are even issues in relation to receiving international funding for fighting diseases like HIV, etc., where there has to be this recognition of what I believe is called now the LGBT community. And at the end of the day, you know, in terms of human rights, we are all human, and do we then start to differentiate based on sexual orientation, based on color, based on belief, based on religion? You know, so it is something that we are going to have to confront in the coming, I think, decade. And I certainly think that with the regional court as our final appellate court, there may be some comfort in at least knowing or believing that the judges or some of the West Indian panel would have that understanding of society's, you know, beliefs and aspirations in terms of that issue.
Over the years, I believe we've had a situation where our law is based on UK law. And, am I correct? I'm making sure. Our law is generally based on UK law. We've had several issues that, for instance, in the 1940s, 50s, and 60s, even before, we've been told, for instance, that if a person commits a certain crime, that they should be put to death. Then the very same UK is now telling us that, no, you should not put that person to death. They told us that when your children are in school, you're supposed to apply corporal punishment. Then the same UK comes back to us and tells us, no, you can't apply corporal punishment. They even say corporal punishment for certain crimes, flogging and so on. Now they come back and they say, no, that's you're acting like animals when you do these sort of things. The UK law told us that there is unnatural connection between a male and a male. Then the same UK is coming back to us now and tell us, no, everything is okay with that. Where do we make the break between what is West Indian, what is Caribbean, what is Grenadian, and UK law? Where do we make that break?
You can start from the premise, Sheldon, that it's one world. I think Michelle was adverting to that just now. It's one world. And mores, customs, habits, thoughts in any one part of the world, given the speed with which people in one part of the world see what's happening in the other world, things in one part of the world no doubt will affect outlook in other parts of the world. We can't get away from that now. Once you have your television, your smartphones, etc., etc., you are exposed to that unavoidably now. The issue then is, to what extent would one society separate itself from what you see on the screen? To what extent can that happen? That depends on a number of things. Religion, culture, education, history, leadership. It's a number of things. We can't depend purely now on a court of law all by itself to change society, or for that matter, to keep society away from change. We all are in it. That is why it is a serious misconception to argue that, so to speak, if you move away from the Privy Council, all hell will break loose. Guyana has been away from the Privy Council, what, since 1973? And they're not eating one another in Guyana. My favorite country, Ceylon, Sri Lanka, they've been away from the Privy Council, what? Years now. Since about 19, maybe 6 or something. They're not eating one another across there. And to me, Sheldon, that is where the buck stops. How can you be telling a people, directly or indirectly, that unless you are logged in to a certain group outside of your country, you are not going to have justice, you are not going to have equality, you're not going to have fairness? That is an insult, a deep insult, to imply that unless you have the Privy Council there to watch over you, your society is going to disintegrate. That's a bitter pill to swallow. And to me, all this argument, well, if you have the CCJ, you're going to have the old school network, you're going to have the Sunday afternoon fair network. That is not justified by our communities. Take Grenada. Grenada, from the day the British landed here in 1763 and pushed off the French, or for that matter, from the day the French landed here and pushed off the Amerindians, Grenada has been going through change. We've changed, whether it was in the day of Fedon, whether it was in the day of Marichaud, Gary, Bishop. This country has shown it can handle change. When change gets out of hand, it is dealt with one way or another. We have seen that. So this country is no stranger to change. We are accustomed to change.
Okay, and folks, remember the number to call 440-7377. That's 440-7377 and 347-329-3101. Those are the numbers for you to call. We're going to take a short, very, very short break and be right back.
Turkey boy, you spent so long in America. What's your opinion about life in Grenada?
Comment.
How have we advanced? Tell me what progress you see.
Yes, indeed, folks. And I think we have a caller online. Let's go to the phone line.
Hi, pleasant good morning.
Good morning to you, ma'am.
Dr. Alexis is so very right. Grenada can handle such changes, right? We have proven time and time again that we can, small as we are. I remember many years ago, listening to BBC News, whatever they call themselves, and there was a statement made by a judge on the Privy Council implying that it is time for the Caribbean to move away from the Privy Council and form their own thing. And I remember at the time when I heard that, I was shocked because, and you know, it's when you hear things like that, it makes you become interested as to what is being said and, you know, this sort of thing. And it's not now. These people want us to move away from the Privy Council. And I think it is a wise decision for us to do so. Let's forget the politics and let's forget the fact that people are saying there may be favoritism. Anywhere you go, they're going to find there are little negatives that would come up. And we just have to be confident and do what is correct and let's move on. I'm not saying let the chips fall where they are, where they think, but let's have, you know, let's put more confidence in our judges, in our local people. Have a good day.
All right, thank you very much. All right, caller, agreeing with you, Dr. Alexis, and with you, Mrs. Steele. that we do have competent, capable people within the Caribbean region who can deal with these issues. And when I remember meeting a few of the justices a couple of years ago, and these were people of high integrity who you cannot say somebody would just call on a whim. Because the other thing is simply this. While people are saying that, okay, a lawyer from Grenada may know one of the judges or so, it's the same thing with the Privy Council, because you go to law school, and you've been to law school in the UK, Your Worship. It's the same thing no matter what. You somehow or the other, you may have gone to the same institution, you may have met a person. But these people that I would have met a couple of years ago are of such integrity that I do not believe, number one, they would excuse themselves from any case that involves anybody remotely attached to them. And they would have that sort of integrity. I'm not worried about having them deal with any case that I would be part of. So I'm wondering where some people are getting this from.
Let me tell you this, Sheldon. I did not go to any law school in London. I was at Cambridge University in England. And the fellowship, the companionship between the bench and the bar in London, between the bench and, say, Cambridge and Oxford or London University, it's far-reaching. When I was at Cambridge, you'd have judges come there and talk to us, and you see them moving with, I wouldn't say fraternizing, moving with faculty members. Some of the judges in London, even while they're on the bench, they still maintain links to their old law firm. Yes? These judges in London, they go to the law schools, they mix with them, and it is never seen as a problem either in London or in the Caribbean. You see, that is why this whole thing about going into CCJ is so important, to help us to educate ourselves and to mature as a people, to appreciate. One person can sit here with you and talk and tell you straight to your face that they don't agree with you, and no love lost. We as lawyers in the Caribbean, we know judges. That doesn't mean that judges don't rule against us routinely, and when they rule against us, we don't go and wimp and cry and say things about them. Of course, nobody likes to lose. Who likes to lose? And that is part of the growing up challenge, that when you've been ruled against, you sit back and you say, maybe indeed the judge was right and I was wrong, and it doesn't matter anyhow. That lawyers argue and judges decide. That's how the system works. Lawyers can't argue and decide. And I've always said to young lawyers, always, never, ever anticipate a court. Meaning, you're in the court, arguments are going on. Don't, because of the way it looks as if the judges are responding to the lawyers, do not, on that basis, come to a conclusion that the case will be decided this way or the other. I've seen it time and again. Arguments going on, and it looks as though the judges are putting more questions to the other side than to you. But when the judges go back to their chambers and they look at the paperwork, they come to their independent, impartial conclusions. And I can't help repeating it. You see this idea of respecting the decisions of the judges and accepting that the judges are doing their best. That is a very important contribution to our psyche, not just as lawyers, but as Caribbean peoples. You take a man like Dennis Byron, born in St. Kitts Nevis, came onto the bench, Eastern Caribbean. When the United Nations wanted a judge, the International Criminal Tribunal decide whether you had wanton killings in Rwanda, they came to him, and he was the president of the tribunal there for years. Caribbean peoples have sat on the Privy Council and written judgments for the Privy Council. A man from St. Paul's, where I'm from, among the least, went to Canada. No recognized name, and he rose to become the Chief Justice of the Federal Court of Canada, not of the Supreme Court of Canada, of the Federal Court of Canada. A gentleman left Grenville and went and became the first Chief Justice of Zimbabwe, those days Rhodesia, Northern Rhodesia. So we have been sending our people from the Caribbean, even from right here in Grenada. The first female Attorney General the United Kingdom has ever had. The first female Attorney General. A lady from Dominica, a baroness from Dominica. So the world has been accepting Caribbean people as being capable, competent of giving decisions, opinions, impartially, independently. How then can we ourselves continue to doubt our integrity, doubt our competence? That's why I say again, you see that argument? I always spend time to respond to it, because this is that argument which tells me we have a lot of educating to do to wean ourselves away from the ways British.
Indeed. I believe we have a caller online. Good morning, caller. Hello, good morning.
Yeah, good morning, Sheldon.
Hey, how are you? Go right ahead.
Morning. Hello?
Go right ahead, caller.
Yeah, Sheldon. No, England, UK had a referendum to move away from the EU, right?
Mm-hmm.
And they were saying that, okay, like, to get any bill passed in the referendum, you got to get 2/3 of any of your registered vote for any bill to pass. But when England had the referendum, it was not 2/3, right? But yet they passed a bill to move away from the EU, and you have England dictating to us what to do, right? But yet they don't obey. They don't do what they're supposed to do. Right? They don't obey in the Privy Council. Well, we in Grenada now have to follow the Privy Council. And Brother Sheldon, when you look at it, it is difficult for a man have a case in Grenada, and he end up now where they have to read the federal code, which is the Privy Council. How would a poor man reach up there? How would they reach up in the Privy Council? Right? But now you find in the Caribbean here, we try to make it easy give easy access to the people of the Caribbean for Liza and Joe to sit on our case. And we have some of us here complaining, we disagree to it. We're not rich people, we are poor and a person. So I remember the case with them in Barbadian, with Jamaica, with the Jamaican girl with the Barbados government. And she didn't have to travel. You had to Liza and Marjorie to sit at the home, wherever sit, and they solve the case. Right? She did not spend no money to travel. So then it become easier for we with the CCJ, right, to work on our case for us. Right? I'm going to look at something again. The culture. A case something happened in Grenada here. Okay? Well, they take it to the Privy Council and they will give judgment based on the culture in England. You feel this is fair, Brother Sheldon?
Yes, indeed.
This is unfair. So you should give judgment based on the culture of where the case happened. Grenada will say that is that I go against it. You face penalty, but based on England culture, they think that they accept or we don't accept it. They will give judgment to the accused, to the person who committed the crime, based on the culture. I say, Brother Sheldon, this is unfair. I support the CCJ 100%. And there is lawyers capable here to do a proper job. There is judge capable to do it. Sometimes we don't appreciate the good people we have, lawyers and judges, but then foreigners, we appreciate them because they feel like they can make a better judgment. And this is something that we have to get out of our system. They're capable, magistrate, capable judge here to sit down and solve our problem. And let us go with the CCJ. I support it 100%.
Thank you. Yes, indeed. And just quickly, some of the comments that I've been seeing here. Hey, Garfield Morning says, very informative program. Deepo is saying the Rinwash episode should be a wake-up call for us all. There's a time for drinking milk and a time for eating meat, not literally. Am I to believe that our educators are deficient in making just calls as it pertains to mediation? No, I don't believe that. And I'm also seeing a comment here where Hannah was asking, Dr. Alexis, if you're heading up the process again, as some people are considering that the process was a failure the last time around. But Matthew also saying you did not fail, meaning you, Dr. Alexis, did not fail. As a certain political leader who would have been guaranteed a seat in Parliament had they not made no their favorite word. So there is a discussion going on the chat right now in relation to the issue. I know you got into it a little earlier, where Dr. Alexis would have mentioned a number of people, the number of the amount of attention that this particular bill would have gotten the last time around. There are noises in certain quarters that a piecemeal approach is being taken to the Constitution. I'm going to offer this question first to you. What do you have to say about that? That some people are saying, why just the CCJ? After you've come to us with 6 bills, now you've come to us with the CCJ. Why just the CCJ bill at this point in time? We know that it got the most attention the last time around, but they're asking.
Well, I'm taking the question first, but I would say that I was not as involved in the process on the last referendum as I am now. But I do believe that the whole issue of constitutional reform was taken as just that, a holistic approach to look at the Constitution and to determine, okay, these are things that need to be addressed, and let us address them all in one fell swoop, as they say. And in the meantime, of course, with logistics and the steps that are taken to leading up to a referendum, it made a lot of sense that this approach would be taken. However, as Dr. Alexis would have indicated, in taking this approach, you were basically asking the people to look at quite a few issues. Some issues did not appear to be too thought-provoking on paper, but then as the national debate got underway, you recognize that, okay, this is really what I think, and what if, and that's the whole point of national debate, and that is why we've had to have that national debate. But I think that in terms of, I wouldn't call it a piecemeal approach, in terms of prioritizing and also looking at what was important to the people coming out of the conversation. The CCJ is certainly the forerunner in that, I don't want to call it a competition, but in that list of issues or desires for us really creating a better document or a better credo to live by. And that is why the CCJ is the focus. As Dr. Alexis would have alluded to earlier as well, the CCJ bill, when it was first presented, contained certain issues in relation to the retirement ages of judges. And there was an issue on the appointment of the Attorney General. And even issues like that, where you thought they would not necessarily create or raise too much debate, those issues sort of got, very, very hotly contested. And it sort of, I think we lost focus on really what is important. What is it that we need to look at right now? What do we need as a people right now? And hence, there's that purity in the bill that's being presented now, and that focus on that one issue versus, bombarding with too much at the same time.
I think we have a call online. Let's go to the phone line. Good morning. Hello, good morning, caller. Go right ahead.
Yeah, good morning, Citizen Scott.
Hi, morning, sir.
Good morning, Citizen Alexis, and your other guest there, Citizen Scott. I have a brief concern I'd like Citizen Alexis to address for me and for the nation. Relative the Constitution amendment pretended to be done as soon as possible. Here's the Citizen Alexis. Can you confirm for me, Citizen Alexis, that another name for the Privy Council is Her Majesty in Council? First of all, before I ask my most significant question.
Yes, Citizen Roller, I do confirm that. If you go to...
Well, I cannot hear you. It's rather unfortunate, so I can't continue.
Yes, if you go to section 104 of the Constitution of Grenada,
Hello.
you will see it written there that essentially an appeal shall lie from decisions of the Court of Appeal to Her Majesty in Council. I don't think...
Seems as though he was having a problem hearing you, so I think he's hung up. But caller, you can call back.
I don't think that the Constitution of Grenada ever uses the expression Privy Council. It uses the expression Her Majesty in Council. The term Privy Council has a variety of alternative expressions. Her Majesty in Council, the Judicial Committee of the Privy Council, the Judicial Committee. The Privy Council judges themselves tend to refer to themselves as the board. There's a historical reason for that, namely, the Privy Council came out into being originally as a committee of Her Majesty's Privy Council, and it was a judicial committee, and it was considered to have a board, and the chairperson of the board was called indeed the president. So you will see those expressions in various pieces of writing. But in our case in Grenada, Constitution refers to Her Majesty in Council, which you know means the Privy Council.
Okay, and let me just say to the caller the error why you were not hearing the Dr. Alexis was due to something I had done on the board. So you can call back if you have another question that you wanted to pose. Absolutely no problem. 440-7377. That's 440-7377. That's the number you can call. We often hear the United States using the term First Amendment, Second Amendment, Third Amendment, Fourth Amendment going up the road. Is it that they had a constitution that they made changes to over a period of time or additions to over a period of time? Or is it a situation that they just took the whole constitution that they had before and redid it?
No, it was piecemeal. You have the First Amendment, as you say, Second, and so on and so on. Some countries have an omnibus change. One bill, you change the entire constitution. They did that in Trinidad and Tobago in 1976. They did that in Guyana in 1980. By contrast, you have had separate amendments, not many. In Jamaica, you have had one in St. Vincent the Grenadines. You have had several in Barbados. And in Belize, they follow the American style of talking about the First Amendment and Second Amendment and so on. So different countries do it different
So
ways.
it's not strange to be attempting it this way. We have a caller online. Let's go to the phone line. Good morning, caller.
Yes, good morning, Citizen Scott. I can barely hear you, but I shall continue nonetheless. At least I shall throw out my question to Citizen Alexis. Citizen Alexis, in the preface written by one W.G. Agnew, the preface to the constitutional order, he refers to the following before the writing of the order. He refers to the fact that Her Majesty pleased and by and upon the advice of the Privy Council hereby makes said order. Now, how can we delink from the Privy Council, Her Majesty in Council, and still be pledging allegiance to Her Majesty the Queen as we seek to go to the CCJ? And finally, how will delinking from the CCJ and adhering, delinking from the Privy Council, Her Majesty in Council, and adhering to the CCJ complete Grenada's independent cycle? In other words, make Grenada an independent nation, eliminating the imperial order and council of the Queen's High Majesty that has us still attached to Her Majesty with the Governor General with all the authority in this here country. How will that happen, Citizen Alexis? Thank you very much.
All right.
The Constitution enables the Parliament of Grenada to alter, amend, not only the Constitution itself, but any other provision which forms part of the law of Grenada. This is how it is always done. You look at constitutions across the Commonwealth, they make the point that the Parliament may alter the Constitution itself or any other clause in any provision, whether made by the Imperial Parliament, London, or wherever else, as long as that provision forms part of the law of Grenada. The Independence Act passed by the UK Parliament will spell that out. In the case of Grenada and the Eastern Caribbean, it's the West Indies Act 1967, passed by the UK Parliament. That act will spell out these things. So there is absolutely no difficulty whatsoever in that regard.
Okay, indeed. 440-7377, 440-7377. Dr. Alexis, Mrs. Steele, where are we at with the process right now? I believe there is to be a parliament sitting tomorrow. Where are we at with at this stage? Where are we at right now with the process?
Currently, there is going to be the first reading of the bill in Parliament tomorrow. So we have basically set up a steering committee. We've circulated the bill for some, comments and whatever else to as many organizations as we could, because we really do think that this national consultation has to be as broadly based as possible, and everyone has to have the opportunity to have a look at it. I do think that we need to also consider that the bill previously would have been put before the nation prior to the 2016 referendum day. And then 2 years later, we are coming back with the CCJ bill. So we have been really trying to mull over these issues and this question for quite some time. And the first reading, after the first reading, we will still have an opportunity to consult. And if there is thought that any amendments are to be made, there would still be an opportunity in relation to that.
Okay, so tomorrow it would simply be the first reading, which
in
means
the House
that,
of Representatives.
Yeah, so any amendments and so on can be made further down
Mm-hmm.
to that. Well, not amendments, but any changes during the
That's
committee
correct.
stage can be made later down
Correct.
in the Parliament. Any timeline as to when Grenadians can expect to once again go to the referendum process, referendum day, any time frame during which we're looking at for that? I don't know if Dr. Alexis wants to take this one.
I'm trying to play. I'm taking his cues.
I do not speak for the government. I don't have authority to speak for the government on these matters, but I would expect that the first thing you have to bear in mind, Sheldon, is that the Constitution requires that there be at least 90 days between the first reading and the second reading. At least 90 days. So let's go forward. If there is a first reading tomorrow is the 15th of May, you add 90 days to that. So you know the referendum cannot be in June, July, August. We know that for sure. That's a good starting point. The second point I want to latch on to this stage is this, and it follows from your question and Michelle's answer. We always say that constitution reform is an ongoing process. Even if you come with a whole omnibus new bill, as in Trinidad, Tobago, Guyana, it still will require reform. As a matter of fact, since the new constitution in Trinidad and Tobago, you have had several new amendments. Since the new constitution in Guyana in 1980, you have had many amendments. Now, because constitution is an ongoing process, and it must be, it's part of life. Law is like life. It's ever changing. They tell you that a constitution is like a tree, always growing and spreading, especially as interpreted by the courts. A constitution is not something you put on the shelf and you admire it as the Mona Lisa. No, it's not like that at all. It's something you work with from day to day. And the fact that we're having this discussion today at all is evidence of that. Now, when we went with this bill to the people in 2016, the people made clear a number of things about this bill as it existed then. They did not like, especially public officers, they did not like the code of ethics. They felt that that code of ethics could have been used against them, although it was intended to be used in relation to ministers of government. So that code of ethics has been scrapped, removed from the bill. Some people did not like, we said, the question of the Attorney General. They felt that you don't have to put that into the Constitution. Or you could answer and say, well, some constitutions have it, as in Antigua Barbuda. Some don't, as in Jamaica. Many people here in Grenada felt you don't have to have it. Again, the question of retirement age of judges. I've had a lot of people say to me, well, judges are not on any pedestal to have a higher retirement age. Well, I could have answered and said as I did, they have increased the retirement age in some countries. Barbados, Trinidad, Tobago, Guyana. And judges are not easy to come by. So you have to increase the retirement age. However, fact of the matter is that it caused debate. So to avoid that kind of debate, we removed it for the time being. So even when the government put out the bill the other day and sent it to us, the lawyers, we looked at it and we said, some of the things you have in the bill should further be removed. And the government has graciously heard our plea and has removed some of those things. So the point I'm making is that right down to referendum day, views expressed by people will be listened to. That is what we've been told by the Honorable Attorney General, Sir Lawrence Joseph, and we believe it because the government has begun to show it will listen to the people.
Indeed. And folks, we're into the final 10 minutes of today's program. We're 10 minutes away from the hour of 12 o'clock, live on 97.5, 89.5, 92.9 out there in Carriacou, and 94.9 out there in Brooklyn. We're speaking CCJ, the Caribbean Court of Justice, and referendum. I want to say referendum 2018. Next thing is referendum 2019. I don't have confirmation when it's taking place. But folks, also a programming note. Tomorrow, due to the sitting of Parliament, we will not be having the live Hard Talk program, but we will be broadcasting the Parliament sitting as it occurs. That will be starting from 9 a.m. if I have my information correct. But Hard Talk will be online from 9. We'll be, I'll speak to 89.5 to see if we can start from 9. But from 10 o'clock on City Sound and the other stations from 10 as per normal. So just a programming note. And on Wednesday, more than likely, we'll be starting with a post-cabinet press briefing. So at 10 o'clock, we'll be starting with post-cabinet, and then you'll be having the conversation. But for now, we're speaking Caribbean Court of Justice. And indeed, and I do hope that you all plan on having the justices visit us again this time around. It'll be very, very important to have them visit once again, to have a conversation with the Grenadian people so that they could interact and realize the quality of individuals who are representing right now on the Caribbean Court of Justice. And the phone number 440-7377 if you've got a question, or 347-329-3101 if you've got a question, or you can pose it on the chat, because I realize quite a few of you on the chat this morning. You can pose your questions on the chat in relation to this issue. So we have touched on the issue of what people are calling the piecemeal approach. It's nothing new. The Americans, they have their amendment, First Amendment, Second Amendment rights, and they quote their amendment. In fact, I think some of them know their amendment rights better than they know the full Constitution and specific ones, especially the ones that carry guns. They know about every American knows that one, whichever one it is. So it is nothing wrong with taking the approach of approaching the issue of the Caribbean Court of Justice, a court that we have significant amounts of money. Dr. Alexis, you have any idea how much money we have into the Court of Justice right now as Grenada? We're having into that court?
That our allocation in Grenada to the CCJ is about $1 million US. And let it be emphasized, we have always been paying that money from the day the CCJ started. It will not be increased on account of our going into the appellate jurisdiction. So whether you are in the appellate jurisdiction or not, that is the allocation you have to pay. And once you are in CARICOM, you are automatically in the original jurisdiction of the CCJ. So what is happening is that we are not using up all the money that we are putting into the CCJ.
It also, one of the things that are being said out there, and I think we need to dispel these things one by one as they come up, is that one country could decide, look, we're not going to pay any money into that again, and basically hold to ransom the judges and the different people within the system. But that isn't
impossible,
so. It's
because
it isn't so.
I'm glad you raised that. Impossible. How the CCJ is financed is this. There is a CCJ trust fund. It is managed by an independent board of trustees. I think that the president of OGBA Organization of Commonwealth Caribbean Bar Associations, is one of the trustees. He is today our own Ruggles Ferguson. These are the kinds of people you have on the trust fund, independent people. When the CCJ was started, it was financed by a lump sum of 100 million US dollars. That sum was raised by the Caribbean Development Bank to be repaid by participating countries. All participating countries have now repaid their share of that lump sum. That capital fund is invested by the Independent Board of Trustees, and the dividends from the investments are used to pay the judges, pay the commission, keep the court going. So it is not as if the court comes to a government every year for money, and if money is not put up every year, they're in trouble. No, as a matter of fact, I'll tell you. I'm glad you raised the question. Some courts abroad are looking at this mechanism of financing the CCJ and inquiring of the trust fund and the CCJ how it is done, because they are interested for their own independence in this kind of financing. So there is no question of Minister of Finance of Grenada not putting up the money for this year, and so the judges at CCJ are going begging somewhere. No, it doesn't happen that way at all.
Indeed. So it can be a situation that Grenada decides what, you had a judgment against the island of Grenada. Or like Barbados right now, they have a case where there was a judgment against Barbados, and they decide, look, we ain't funding, so the thing was crash. All you go know better next time. All you must pass judgment in favor of us. They are immune from that. Because the revolving fund is basically like you have money in the bank and you're living off the interest. You ain't touching the money, but you're living off the interest. So there's enough there to pay the judges and for the operations of the court, without having to be beholden to any external force again. It is a revolving something that's there that they can get the money out of.
Yes, it's a trust fund. It has its own independent board of trustees, and they've been doing excellent work deciding what they're going to invest in. Of course, no investment is foolproof anywhere in the world. It's a fact of life. But basically, the fund has been maintained at that 100 million US dollars. If it goes down, at the crash of certain financial institutions in the Caribbean not too long ago, the trust fund suffered from that, but it in no time got back up to its level. And I'm not suggesting for a moment that the trust fund will never need capping up. Of course it can need capping up from time to time. And you cross that bridge when you get to it.
But Sheldon, just to add, I'd like to invite you and your listeners to have a look at the CCJ's website, which is ccj.org.org. And it not only tells you about the court, it also tells you all about the financing of the court, the CCJ Trust Fund. You can read certain of the judgments that have been delivered by the court, and really get a chance to. I know there's a lot that we can talk about, but we only have limited time. But it allows you to explore and sort of get into the real nitty-gritties of your curiosity.
Indeed. And folks, remember that's www.ccj.org. You don't even want to type the www again.
Yes.
The internet is that way now. Just type ccj.org and it'll take you to that website, and you could get direct. Well, you see, it's hard talk. We just tell you where to go and get the information, Or we just call people like Dr. Alexis or Mrs.
Michelle.
Michelle Steele to try and get the information for you. Yeah? So definitely. And I'm glad that we've been able to clear up some of the misconceptions in relation to the CCJ this morning. But I'd also like to invite you all back at your earliest convenience to once again speak on where we're at with the process after the reading, the first reading tomorrow, and to discuss further, because I know other issues are going to come up, other discussions in relation to this issue are going to come up again. And definitely we know that this is an issue. And folks out there, look at it as this way. As it is right now, it means that justice, which should be available to each and every one of you, is not. Because the price is prohibitive unless you have a couple $1 million somewhere away. And even if you have a couple $1 million, because you could be a major business in Grenada and you have a major case against another business, and because of the price to go to the Privy Council in the UK, you may decide against it. It could be that the payout you're discussing, let's say you're discussing $200,000, $250,000, and you're discussing that. But by the time you take that case to the Privy Council, you're going to be spending close to $1 million. So you wouldn't want to go to the Privy Council as a businessman and maybe a big business in Grenada, and you're going to the Privy Council to fight a case where you have the possibility of gaining $250,000 and you're going to spend $1 million to do that. It just does not make sense. So even for quote unquote big businesses, it still means that they cannot receive fairly the justice that they really deserve. Whereas we are paid, we have the Caribbean Court of Justice there, that whether it's big business or it's a child in school who decides to file a, yes, a child can file a motion, it happens. A child decides to go in and file a particular motion, they want it to go to the Privy Council, no matter who it is, the CCJ would be able to handle that. But when it comes to the Privy Council, forget it. Policemen, nurses, teachers, vendors, all of you basically have to forget that one. It would not be possible. So justice, as we said, has to be, how did you put it a while ago, Mrs. Steele?
Justice delayed.
Justice delayed.
Is justice denied.
Yes, indeed. And Naz, you get it phone there? Naz can find out to put the phone on silent. Just turn it over and turn it back. Just turn it over and turn it back. Yeah, that silences it. Yeah, so someone wanted to get to Dr. Alexis quite quickly. So, folks, any closing words? We'll start with the lady first. Any closing words?
Well, I'm very happy that we are able to come on to the program. Thanks again, Sheldon. As you say, to start this series of public education awareness. Thanks again for the invitation to come back. And I think we certainly will take you up on it. Remember, folks, it's ccj.org. Hopefully by then, by the next time we're back on the program, everyone would have had a look, refreshed their memories, and we would have a whole new slate of questions to answer. And we can really get the debate going. It's very, very heartening to hear your listeners and the callers that called in this morning, and to hear the comments. And you know, I know that we are on the right road and on the right track, and we understand what's at stake here.
Yes, indeed. Dr. Alexis?
Thank you very much for having us, Sheldon, and your listeners. What we are saying is that we have heard loud and clear comments made by Grenadians, Carriacouans, Martinicans on this bill in 2016. The parts of the bill that the people indicated they were not happy with, we have excluded those parts from this bill. We have cleansed it up. And so we present the bill to you for your best consideration going forward, for your sake, your children's sake, and your children's children's sake. Thank you very much.
All right, folks, that's it for Hard Talk for today. Remember, tomorrow we're going to have that Parliament sitting, and then on Wednesday we're going to be starting, first of all, with the post-cabinet press briefing, God's willing, and then going into Hard Talk. And we'd like to thank so very much again Mrs. Michelle Steele, and Dr. Francis Alexis for taking time from their busy schedule. Their lawyers, this time of morning, they're supposed to be in court. You understand? So they leave where they could be out making a look a dollar, and they come to discuss an issue that is important to not only national development, but personal development for each and every one of you. I mean, right now, you may never have even set your foot in a court, but next thing you have to set your foot in a court, and you want to make sure that you get justice. And then you reach to the stage that you can't get to the Privy Council. What are you going to say? That you should have done something that you should have done before? No. We're going to make sure that we give you the information, and we're going to take the questions from you. So let's say at least 1 month from today that we're going to have another discussion in relation to this particular issue. And I'll keep myself to that. 1 month from today, we're going to have another discussion in relation to this particular issue. Folks, it's been wonderful being here with you. To all of you out there, all the radio stations, all of the listeners online, we'd like to say thank you so very much. And remember, we love each and every one of you. And in everything you say, everything you do, remember, we want to be speaking to and with you and not about you. Be safe, be careful out there. That's our talk for today.
Greetings, people. It's a two-time groovy monarch, the man himself, Dash, the lyrical assassin, the groove man. 2 years in a row I've been capturing the groovy monarch of Grenada, going for the 3rd year to create history. So come and witness on the night now, come and enjoy, because remember, we're grooving, and over the years we know groovy monarch has been growing. Performance, the energy, the stage, everything just been different over the years.
You're the set, and so the girl looking best. Sing this. I feel I go on again. Keep up it. You are the best. Keep up it. No personal. All on the road, inside the bank.
So come out on the 10th and witness pure energy, pure vibes, music, bacchanal, rags, flags. Witness history as I go for the 3rd one, to defend and to bring it home, back to the Ville. Remember, down the road, where we go, in 118, the 120 zone. Out!
Pop your fist and move where you wanna move. Let me make them go. Once I'm here, I think for the easy no more. None of them are ready for the catastrophe. I got you.
This year promises to be a spectacular affair as beauties of the Caribbean compete on one stage for the title of Miss Caribbean United. Come see contestants from the islands of Trinidad, St. Lucia, St. Kitts, Nevis, St. Vincent, Anguilla, Dominica, Venezuela, Antigua, Dominican Republic, Margarita, Barbados, and host country Grenada. It's the 2018 Miss Caribbean United pageant, Saturday, June 2nd at the Spice Basket, uniting the Caribbean through beauty.
Spice Mass Corporation presents White on the Sea, the Glow Cruise, Saturday 26 May, aboard the Brother 2. Come party with the kings of our Soca Kingdom, St. David's Monarch, Blaze, Tonic, 2 times and reigning Groovy Monarch, Dash, 2 times OECS Monarch, 2 times Road Match, 4 times and reigning Soca Monarch, Boise. Tickets cost $40 with barbecue included. Get your tickets now from the Spice Mass office at the GCNA Complex, Kirati James Boulevard. Any Spice Mass Corporation member, Mitchell's Pharmacy in Grand Anse, or call 440-0621. Boarding time 7 p.m. White on the Sea, the Glow Cruise. You must wear white.
There's so much going on with the NNP, and we're just getting started. From candidate launches to contests, events, and breaking news, be in the know. Get notified first about big events and announcements. Plus, we're here to listen. We want to hear from you. Leave us a comment, tell us what's working and what's not. Like what we're doing? Let us know. The NNP is working for you. Interact with us on Facebook. Come on, Grenada, get connected. Like us on Facebook /NNP Grenada and keep moving.